I'm Paul Jacob, President of Citizens in Charge Foundation. A very important case, Doe versus Reed from Washington State, is headed to the U.S. Supreme Court. The case pits two fundamental values, disclosure or transparency versus the privacy rights of people who sign a petition. Because we're a group that believes in an open and accessible initiative and referendum process, we wanted to hear from both sides in this important case.
Hi, I'm John Miles. I'm part of a legal team that filed an amicus curiae brief in the case of Doe versus Reed. The brief was submitted on behalf of 30 organizations, mostly nonprofit organizations under Section 501c3 or 501c4 of the Internal Revenue Code, all of whom are interested in the correct interpretation of the U.S. Constitution. Doe versus Reed presented these organizations with an opportunity to take a position on an important public policy question that has to do with anonymity in the electoral process and whether the free speech guarantee of the First Amendment protects individuals in their capacity as legislators in the initiative and referendum process. Our organizations supported the petitioners, saying that this is a free speech issue and that anonymity is a critical factor in protecting that guarantee of the First Amendment. Essentially, we argued in this brief, contrary to the argument of the state of Washington, that freedom of speech does indeed apply to the legislature and the legislative process. So it is a freedom of speech case, and the freedom of speech does play a role here. And the impingement on the disclosure of the identities of the individuals in question would impinge on that First Amendment guarantee. Our argument, slightly different from the one presented by the petitioners, is that this right to participate in the legislative process given to citizens here is secured by Article 4, Section 4 of the Constitution, the Guarantee Clause, and that this guarantee is a privilege and immunity of U.S. citizenship that the states may not abridge.
I'm Tom Lang, director of KnowThyNeighbor.org, based in Massachusetts, and we got involved in the initiative petition process in Massachusetts back in 2005, working on an anti-gay marriage petition that was being circulated around the state. Know Thy Neighbor is on the side of Reed regarding Doe versus Reed, which is a SCOTUS case happening at the end of April regarding Referendum 71 and the release of signatories for Ref 71. Not only is Know Thy Neighbor on the side of Reed, meaning that we believe in the initiative petition process being as transparent as possible, that the signatures, when people act as citizen legislators, are actually allowed to be public, as it always has been, but also Know Thy Neighbor, from a historical standpoint, is really the reason with WhoSigned.org in Washington why we actually have this SCOTUS case going on right now. If Doe is successful in the case of Doe versus Reed, in other words, if the signatures involved in initiative petitions are not able to remain public information and they're not able to be released to the public, we see grave implications around the country where election laws will change in states and people will not have access to the signatories. Why that is important is because, again, in the fraud and policing case, and also understanding and knowing who's behind an initiative petition.
Hello, my name is Ross Day. I'm the Executive Director and General Counsel of Common Sense for Oregon. We're a nonprofit, nonpartisan organization dedicated to protecting the initiative process here in Oregon. Common Sense for Oregon filed an amicus brief on behalf of the plaintiff petitioners in the case of Doe v. Reed. This is a very important case from our perspective because of what we've seen happen over the years to the initiative process. In Doe v. Reed, by allowing opponents of initiative measures the ability to go out and discover the names of folks who may have signed a petition and then publish those on a website or some other public material in such a way that will allow those folks to be the subject of harassment, will only further hamper the efforts of proponents of direct democracy circulating petitions and getting their measures on the ballot. The key in Doe v. Reed, as it is most of these cases, is a fundamental misunderstanding by the courts of what it means to actually sign an initiative petition. While I agree that signing a petition is a form of speech that should be protected by the First Amendment to the United States Constitution, signing a petition in and of itself does not necessarily express one's support or opposition for a ballot measure. In fact, here in Oregon, a person who signs a ballot measure petition specifically says on the petition sheet that they are merely asking the Secretary of State to place the question before the voters. It does not imply support or even opposition to a measure that they may be signing the petition for. And so I think that was a fundamental misunderstanding by the courts in Doe v. Reed, which leads to the implications that allowing folks to publish those names and misrepresenting the nature of those signatures and what those signatures actually mean will dissuade folks from actually signing a petition. I know many people who sign petitions just on principle because they believe that measures that are important to a large enough portion of our citizenry should be able to put those measures on the ballot.